22 years ago, a church gave a portion of its land to build an independent Christian-based school. So it doesn't specify what gave means, whether it's ownership or whether it's just use and possession. The parents and community built and maintained the school. The church didn't require any rental as it was a community-enriched initiative. So it sounds like the school was also some kind of a non-benefit organization or something like that. 22 years later, a new pastor came, and now he wants to demand that the school pays rent. What can I do?
Sure, that's a tricky one, Bruno. And I think one of the things that I picked up in the question now that I didn't necessarily notice when I read it was the fact that it's an independent Christian-based school, which tells me it would be independent from the Department of Education. And it does actually change my answer a little bit. So let's quickly take, just for sake of looking at the law now, take the church and the school element away from it. It does change it a little bit, but strictly speaking in law, say you have a piece of land and I say to you, Bruno, you know what? I have this piece of vacant land. Don't you want to build a house? You just pay for the building material, you set it up and then you can live there. It's such an open-ended kind of agreement, which in my mind already doesn't comply with the essentialia of lease agreement. One of the essentialia of lease agreement is that there must be payment of rent, and the use and enjoyment that the tenant enjoys must be temporary. Now, in the context where you let somebody build on your land, and then especially for something specific, not charging rent, and it doesn't feel like that agreement at the time was temporary, tells me that this is not a lease agreement. I can't see how the church currently can come back and say it's a lease agreement, but it doesn't mean there's nothing and everybody can just carry on as it is. What happens here is if there wasn't a transfer, and I don't think there was, it doesn't sound like there was a subdivision and then transfer of the land. So the land belongs to the church. The church, as the owner of the land, can effectively do with the land as they see fit. However, the school was now built with money from the community and from the parents of the school. So we can say it was done by the school, because even though they got their money from wherever, it was done by the school, which means the school invested and increased the value of the property. And the church would be able to, at some stage, then start charging a form of rent or whatever. But this is one of the rare cases where I would say I see a valid and highly enforceable claim in lien. Claim in lien is where a user of land, somebody that doesn't necessarily have the right of occupation, but they have the right to use the land or do something on the land, and they increase the value of the land, because a piece of vacant land is, X value. And the moment you put a building on there, it obviously changes the value of that. So before the church can start claiming anything from the school, the church will first have to compensate the school for the increase in value to the property as a result of the buildings on the property. So the truth is, because it's a school and because it's a church, there is a very high level of community involvement here. We can't just look at it as I'm giving land to somebody and I'm letting them build and where are we now? It is relevant, and it's very relevant to consider that we can't just, the landlord can't be in a position where he just now randomly kicks the school out. There are kids that will have to go to school and it's going to interrupt their education to just kick them out. there's quite a lot of case law around that. A school has to be treated very carefully when it comes to cancellation of the rights. And usually you want to do it at the end of a school term, so you don't interfere with the right of the kids to have undisturbed education. So what I would recommend in a situation like that, practically, is to sit around a table and say, okay, church, for 22 years, you haven't charged rent, but we've increased the value of the property by X amount. Do a quick calculation and then come to an agreement. But this, our dear viewers, is why I love things to be in writing. I will do business on a handshake, and if I can't do business on a handshake, I probably won't. But I always back my handshake business with a contract, because the parties to the handshake agreement, somewhere somebody will die, or be stuck in a moon boot for 6 weeks and maybe out of reach, or whatever the case might be. It's important to know that, and it's important to know if we don't record things properly in writing, parties end up in a situation like this. So at this point, the church can definitely not just say we need to start charging rent, because there was never a lease agreement in place of any sorts, not even a tacit lease agreement. There was a right of occupation, and the school does have possession, whether backed by a specific legal something or not is irrelevant. They have possession, and the church definitely can't just keep the school out. But I would have to, you guys will have to sit down, do a calculation about the claim in lien, what is the value that the school added to the property, and then come to an arrangement of rent, when will they start paying rent, and then turn this relationship into a lease agreement. What did I miss, Bruno?
No, I think there's so many different problems that we're having here, but I think you answered most of it. The only thing I'd add on is maybe has to have a conversation with the previous pastor, have a conversation with the people that were originally involved in this, because it's, we don't want a situation where there's some kind of dispute of fact where, somebody claims, oh, but the idea was that you would build and then you would use for free over a period of time. And after the lapse of that period, then either rent would be payable or you'd return the property to us or something along those lines. So we don't know what the underlying agreement was, and we're not putting a lot of focus on it because the question just says they gave, we did, and now they've got a problem. But what do the people remember communicating to each other? That might also change our answer quite a bit. So I think start where you need to start, which is what really was the initial agreement. And is there proof of that? If the previous pastor is the one that made the decision, approach him and go, what did you have in mind when you gave it to us? Even if he says, oh, no, I thought you were going to pay rent, that's a different component, because then you can argue, oh, but you didn't communicate that. But at least if you've got his support where he's like, no, totally agree. The intention was never to make you pay rent, but yes, we would need the property back at some point, then Cilna's answer covers it all.